you very much, Professor Weeks, and thank you also, Professor Andrews. I was, of course, really delighted to have your invitation to come here to speak to you today to celebrate the Pearl Jubilee, the 30th anniversary of the Faculty of Education. I knew I was in very safe hands because in the office that the faculty gave me today, there's a lovely bag that says, "Trust me, I'm from education." Well, I was asked to speak about freedom of speech, but I have to admit that I should accept full responsibility for the title, Charlie Hebdo, but I thought it was some way of whetting your appetite and exposing, at least in a very particular way, what it is that I really wanted to speak about tonight. Please accept my congratulations for the 30th anniversary. In fact, it's the 30th anniversary also of the Australian Human Rights Commission, so we share that. But what I'd like to do, if I may, is start not entirely at the beginning, but almost at the beginning, because as you'll know, this year we celebrate the 800th anniversary of the sealing of the Magna Carta by King John. I say sealing very deliberately because it seems that he was illiterate, couldn't write. He didn't ever sign the document, but he did place his seal on it. Well, it remains true, it seems to me, that the fundamental freedoms that the rebel barons fought so hard to protect from arbitrary power of the sovereign remain under very significant threat today. As is oft said, the price of liberty is eternal vigilance. The continuing need to be vigilant applies to many of the freedoms that underpin contemporary democracy and the rule of law, including freedom of speech. But the freedom to say what we like is not an absolute right. It needs to be balanced with other rights and freedoms. Many restrictions on freedom of speech are commonly accepted in most legal systems. Laws that limit, such as censorship, laws that prohibit, such as sedition or pornography, laws that protect reputation or trade secrets or other intellectual property, laws that set broadcasting standards, restrict advertising, or enforce confidentiality agreements, or laws that regulate political protest, even here in Hong Kong. Well, today I would like to focus on a limit on freedom of speech that's less commonly understood. That is prohibitions on speech that promotes racial or religious hatred. Governments typically justify such laws as necessary to promote racial harmony, a social value that's increasingly important to nations that are multiracial, multicultural, and multi-religious. Last year, the United Nations Secretary General estimated that nearly 60 million people were displaced and moving into countries other than their own, most coming from conflict, persecution, and poverty from Africa, Latin America, and the Middle East. Racial harmony has thus become critical to global order in our interconnected world. Indeed, within the Asian region, racial harmony has long been recognized as fundamental to peace and good government. Today, I would like to explore the proper limits on racist speech and briefly consider how China, Indonesia, Malaysia, and Singapore restrict speech, both as a matter of law and as a matter of practice. As an Australian lawyer, I would like to focus on Australian laws and practices, especially as over the last year or so, we've had an unprecedented public debate on the legitimacy of racial abuse laws. Prompting recent worldwide concerns about the proper limits on freedom of speech has been the murder of the journalists at the French publication Charlie Hebdo in January earlier this year. Sparking the tragedy, it seems, were several cartoons depicting Muhammad that were highly offensive to Muslims. These cartoons were typical of Charlie Hebdo and indeed of some other publications, depicting Jews, the Pope, and various political subjects. And while I don't want to offend anybody at all here today, I thought it would be useful to look at some of these cartoons to get a sense of just how offensive they are in your judgment, but also how varied they are in the subjects that have attracted the work of the cartoonists. This one is the gay lobby on conclave. The bishops of the Roman Catholic Church in what many as Roman Catholics would see as deeply offensive as a method of depicting people who are greatly respected within the church, and of course in the process of choosing the new pope. Then we have another one, the Pope here in the Vatican, with regard to sexual orientation, at last I'm free. Then we have here we have a Muslim saying 100 cuts if you're not going to die of laughter. Here we have a terrorist. We've avenged the Prophet Muhammad, and we shall avenge Charlie Hebdo, being the cartoonist at work. And then we have another here, freedom to speak, freedom to think, and freedom to write, and the freedom to kill. Now, there are many others, and one that perhaps you're most particularly familiar with is the cartoon of a Danish cartoon, in fact not Charlie Hebdo, that depicted Muhammad wearing a bomb as a turban. It was a very simple picture, but it was one that caused great anguish and hurt in Asia. The legal question that I'd like to explore is whether cartoons of this kind should be protected as freedom of speech or restricted in the interests of racial or religious harmony. Well, an indication of how a French court might respond to these cartoons was provided by a decision in 2007, quite a while ago, but I think legally valid, in Great Mosque against Val. And it concerned France's laws which prohibit insults and incitements to discrimination, hatred, or violence on the grounds of race and religion. And they were looking in particular at the Danish cartoon, as I've said, depicting Muhammad wearing a bomb as a turban. The court decided that the cartoons were valid under French law. And repeating again those words, were they an insult or an incitement to discrimination, hatred, or violence? And the reasoning of the court was that the cartoons insulted only violent Muslims, and that in a secular and pluralist society such as France, the respect of all beliefs goes hand in hand with the liberty to criticize religions, whichever they might be. Well, that was the view of the court some 8 years ago. But one might question the validity of this decision, as the cartoon appears to link extremist terrorism with Islam, and to make the imputation that all Muslims are disposed to violence. The reasoning in the Great Mosque case nonetheless appears to reflect the very strong commitment by the French community to the idea of protecting freedom of speech, and of course of the media and press generally. Indeed, the public response to the Charlie Hebdo killings appears strongly to support protection of the publication, even if it could be demonstrated that the cartoons were causally connected to the killings. The Charlie Hebdo killings divided global responses. Some commentators, including Peter Carey, the Australian writer, have argued that while they support free speech, racial and religious hatred should be banned. Others, such as the very well-known author Salman Rushdie, called Peter Carey and others the But Brigade, and support free speech, but Rushdie says there should be no prohibitions at all on hate speech. At the political level, calls for restriction on speech that promotes racial or religious hatred do appear to be growing. England's Labour Party has called for a law to outlaw language deemed offensive to Muslims. Russia has passed a law forbidding Nazi propaganda. The London Declaration bans anti-Semitism, and the Organisation of Islamic Conference has recently demanded the creation of global blasphemy laws. Just a week or so ago, Australia's Attorney General expanded the debate about hate speech, arguing that terrorist propaganda is one of the greatest threats he believes exists in respect of Australia. Accordingly, he proposes further legislation beyond that of advocating terrorism, a new capacity to monitor all social media to identify those who might advocate terrorism. In such a volatile and controversial environment, it might be useful to revisit long recognised and fundamental principles of public international law, and indeed the origins of freedom of speech, because they lie as a central component of democracy in the modern era in the work of the father of liberalism, John Locke. Locke influenced the adoption of freedom of speech by the First Amendment in the American Constitution, the first constitutional protection of this right, and a right that's recognised as enabling democratic governance and vital to the rule of law. The right to freedom of speech was subsequently adopted in many national constitutions and legislation, and the common law courts have developed free speech jurisprudence on a case-by-case basis. After the Second World War, the international community, through the United Nations, gave effect to the right to freedom of expression in the 1948 United Nations Universal Declaration on Human Rights, and later, in 1966, in the International Covenant on Civil and Political Rights, the right to freedom of expression was expanded. Article 19 of the International Covenant provides everyone shall have the right to freedom of expression, subject to certain conditions, such as are provided by law and are necessary for respect of the rights or reputations of others, for the protection of national security or of public order, or of public health or morals. Now, I imagine not all of you are lawyers here, but you'll understand that that's extremely wide-ranging language. In other words, you have a right to freedom of speech, but those rights can be reduced in relation to protecting reputation, national security, public order, public health, or morals, giving, of course, courts a very wide scope in interpreting actually what that means in practice. The general test, however, for the limits and the validity of limits on freedom of speech are that it must be reasonable and necessary and proportionate as a means of achieving a legitimate objective. So you have a legitimate objective, and a restriction on speech can be valid if it's reasonable, necessary, and proportionate. But there's also, in addition to the general right to freedom of speech, a positive obligation under Article 20 of the International Covenant on Civil and Political Rights to prohibit any advocacy of national, racial, or religious hatred that constitutes incitement to discrimination, hostility, or violence. And these terms were given greater precision by the Racial Discrimination Convention that was prompted in part by a global epidemic of anti-Semitism. This convention condemns the promotion of racial hatred and requires states to make it unlawful to disseminate ideas based on racial superiority or hatred. These international obligations aim to prohibit both racial and religious speech. It's interesting that many of the ways in which the Race Discrimination Convention has been implemented in domestic legislation will not specifically mention that it includes racial abuse as well, or discrimination as well as religious. But most courts, at least in the common law systems, have seen it in those ways. The Chief Justice Dickinson of the Canadian Supreme Court has said that states now have an obligation to prohibit racist propaganda that undermines the dignity and self-worth of target groups and contributes to disharmonious relations among racial, cultural, and religious groups, with the result of eroding the tolerance and open-mindedness that must flourish in a multicultural society committed to the idea of equality. Well, in addition to the international standards that I've been describing, has been a tendency of many countries to retain their anti-blasphemy rules. There's no right not to be offended on religious grounds, at least not in international law. But many countries have enacted anti-blasphemy laws to prohibit speech that insults religion. International law will permit anti-blasphemy laws so long as they are reasonable and proportionate and do not discriminate against or in favour of one religion or another. Blasphemy laws can't be used to prevent or punish criticism of religious leaders or commentary on religious doctrine and tenets of faith. Their use, for example, in Pakistan to harass religious minorities and moderate Muslims clearly breaches Article 20 of the International Covenant. You might be interested to know that the Australian Human Rights Commission has recommended abolishing Australia's blasphemy laws because they protect only the Christian religion, but no others. That seems inappropriate in terms of equality laws, and we felt that the better thing to do was to abolish the blasphemy laws rather than try to defend them in relation to one religion only. But now, if I may, I'd like to turn to a more regional approach to the protection of freedom of speech and consider how freedom of speech protections are provided by China, Singapore, Malaysia, Indonesia, and finally Australia. But also to ask the question how these jurisdictions might respond to cartoons such as those that sparked the Charlie Hebdo killings. I think the questions are worth exploring because of what I see as the general exceptionalism in relation to human rights within the Asian region, and perhaps most particularly the exceptionalism of Australia. For this region, unlike Europe, Africa, Latin America, and Arab nations, does not have a Charter of Human Rights or a commission or a court to develop a regional human rights jurisprudence. The closest agreement among Asian nations on human rights is the ASEAN Declaration that includes a free speech provision in Article 23. That ASEAN provision is that every person has the right to freedom of opinion and expression, including freedom to seek, receive, and impart information. That is a provision that is common, of course, to all of the regional charters of human rights. But what is different is that the ASEAN Declaration then sets out a very broad exception in Article 7. That all the rights set out in the Declaration must be considered in the regional and national context, bearing in mind different cultural, historical, and religious backgrounds. The right to freedom of speech is subject to such limitations as are required for national security, public order, and public morality. So we have an unusual provision in the ASEAN Declaration that gives particular weight to the regional context of cultural, historical, and religious backgrounds as a valid limitation on the right to freedom of speech within the region. So we don't yet know how that is going to play out in practice. Certainly the ASEAN Declaration has been much criticised within the region and externally. It is not legally binding, but of course I know as a public international lawyer, and I'm sure you understand, that the Great Declaration, the Universal Declaration of Human Rights, is not a legally binding instrument either, but it has been formative in encouraging the creation of normative cultural expectations about human rights that have then been reflected in the major international human rights treaties at a later stage. And it's really with that background in mind that the Universal Declaration on Human Rights led to the International Covenant on Civil and Political Rights and the other major treaties on economic, social and cultural rights, the Convention on the Rights of the Child, the Convention Against Torture, the Convention on Discrimination Against Women, and the Disability Discrimination Conventions have all been built on that rather perhaps fragile declaration in 1948. And so too, although there has been much criticism of the ASEAN Declaration, I see it as a very significant step for the region to collaborate and to agree upon core principles, even though there are very wide exceptions that will doubtless provide a basis for laws that perhaps in other parts of the world we would find unacceptable. But I do personally believe that this is a foundation for a shared commitment to most of our human rights, but particularly, of course, freedom of speech. Well, as has been mentioned by Professor Andrews, I'm not an expert on Asian law, although I have been to Asia many, many times and worked for many years with a law firm in Asia on domestic laws, but I've not really delved particularly deeply into the national human rights laws that countries within the region have adopted. But I have had a research assistant who's been working with me, and we have produced a spreadsheet looking at the various laws and practices in the region. I won't go through that, of course, with you now, but I will append it to the paper, and you're welcome to have to use it from the Department of Education or the Faculty of Education in the future. But one lesson I have learned from going in detail through each of the Asian nations, including Australia, is that constitutional laws, legislation, even developed jurisprudence by the courts, tells only a very small part of the story, because it's almost impossible to know from the paper research exactly how human rights are given effect within particular jurisdictions. So that one really needs to look much more deeply than I've been able to at just how human rights work in practice in the region. But it does seem clear to me that very much depends on cultural or normative expectations of the community in which these laws are applying. If the community has a different expectation about human rights, then that community can be very powerful in ensuring that political representatives comply with those rights. Equally, of course, constitutional provisions and legislation are not always matched by a commitment by our political leaders or even by segments within the community. So perhaps the best way of understanding how these laws operate in practice is to watch at a very local level to see what kinds of rights apply and are allowed to take place before prosecutions or police intervene, and we see that very tiny number of cases that actually get before the courts. But generalising, Asian countries almost uniformly protect freedom of speech at the constitutional level, but they retain very broad caveats in the interest of the state, and they use quite frequently sedition laws to control that speech. Were these Charlie Hebdo cartoons to be published in Asia, there are at least two differing legal approaches. China, Hong Kong and Australia are very likely to ask if the cartoon is discriminatory on the grounds of race or religion, while many other Southeast Asian nations, and in part China as well, are likely to prosecute on the basis of laws that prohibit religious insults and protect national security and harmonious relations. Hong Kong, I understand, prohibits racial abuse through the Race Discrimination Act, but I understand it's not used very often. And it's not entirely clear if the law applies to religious discrimination as well as racial discrimination. The Hong Kong Equal Opportunity Commission website states that religion is not a race under the Race Discrimination Ordinance. And now that is exactly the opposite of the position that's been taken by many other jurisdictions around the world, but perhaps most relevantly from my point of view from Australia, where racial discrimination is seen as including religious discrimination. Indonesia's constitution guarantees the right to express opinions, subject to respect for the rights of others and considerations of morality, religious values, security and public order in a democratic society. But to insult a major religion under Indonesian law will attract a 5-year prison term. And some of you may be aware that the editor of the Jakarta Post has recently been charged under that offence last year for a cartoon that mocked ISIS. And it is interesting, again, looking at this area of law, how frequently it is the cartoonists who are prosecuted rather than the journalists. I sometimes wonder if that isn't because the cartoonists using humour can be far more powerful as a political tool than the journalist, where you've got to actually read the substance of their thinking in order to reach a conclusion. Humour is a very, very powerful weapon, and perhaps that's why cartoonists are so frequently attacked. Under the constitutions of Malaysia and Singapore, freedom of speech is guaranteed, but they criminalise seditious tendencies which are prejudicial to the state. Under the Sedition Acts, they prohibit speech that promotes feelings of ill will and religious hostility between races or classes of the population. These sedition provisions are rarely used in practice in Singapore, but the laws are much more frequently employed by Malaysia. Recently, for example, again, a cartoonist was prosecuted by Malaysian authorities, a person who had he was criticising the bringing of sodomy charges against Anwar Ibrahim, of course, the leader of the opposition in Malaysia. China's constitution stresses that its citizens enjoy freedom of speech and of the press, so long as they don't infringe the interests of the state or of the collective or of the freedoms and rights of others. Discrimination laws appear to apply to nationality or ethnic groups, but not to religion. China will, for example, prosecute a publication that discriminates against or humiliates an ethnic group. For China, it seems, the primary focus is on national security, and it's via national security that I'd suggest that any speech that incites ethnic tension or violence will be prohibited. Thus, it's probable that China would prosecute for speech that incites religious hatred. Well, that's just a very brief run-through of some of the major countries in the region, but what about Australia? Has Australia met its international legal obligations with respect to freedom of speech? By contrast with most states in Asia, Australia has no formal protection at all for freedom of speech. But it's at least arguable that it has stronger practical protections for freedom of speech in the day-to-day lives of most Australians. It's not the constitutional or legislative protections that are important, but rather the normative culture within the community that insists that freedom of speech and other freedoms are protected. I think it's fair to say that Australia has been an active player in drafting the human rights treaties, to which we almost invariably become fully ratified parties. It's thus all the more curious that Australia has been very cautious and piecemeal in implementing international human rights obligations in our national law. Australia is entirely alone among comparable legal systems in that it has no express constitutional protection for most human rights. No other common law system fails to accord these rights in their systems of law. We do have a constitutional exception, and that is that there is a right to religious freedom in Australia, but the purpose of that provision was to prevent religion ever being established in Australia. It was less intended to protect the individual's right to choose their own religion. There's also a right to vote and a right to be compensated if property is taken by government. But that's all. Absolutely no other provisions to protect human rights in the Australian Constitution. Moreover, of course, Australia has no Human Rights Act or legislation or charter or Bill of Rights, and most of the human rights treaties to which we've become so readily party to in the international arena, such as the International Covenant on Civil and Political Rights and the Convention on the Rights of the Child, have never been implemented in domestic laws by Parliament. And I'm sure you'll understand that in the Australian legal system, Parliament is sovereign. It represents the sovereign interests of the people, and no treaty can be valid in Australian law or implemented directly in Australian law unless it is first implemented by legislation through Parliament. That makes, of course, impeccable sense from anybody understanding the way the democratic process works, but it can also be extremely damaging if all political, but at least both major parties, agree that they will not allow Parliament to be used as an instrument to implement those human rights treaties in the domestic legal system. Rather, Australia has created a regime for the protection of human rights that's essentially parliamentary and administrative rather than constitutional or legislative, so that all the processes for protecting human rights lie in Parliament itself. And that is where we have a significant problem, as I mentioned a moment ago. If both parties agree upon legislation which infringes human rights, then the courts are bound to apply that legislation because of parliamentary sovereignty. We have no benchmark against which a lawyer can then go to the courts to say, but what about the Bill of Rights, or what about the constitutional provisions? There's no benchmark against which you can manage these sorts of issues. However, there has been a tendency to rely on the common law, and you'll hear many in Australia say, yes, but we have the common law tradition. The High Court has implied a right to freedom of political communication as a necessary means of participation in a parliamentary system of representative and responsible government. Now, I think it's fair to say that the High Court, in implying this right of political communication, is very unlikely to overrule itself, so I think we can say that it's a fairly solidly accepted right. but it's not the same as the full right of freedom of expression, and it finds its roots exclusively in the Constitution itself and the right to vote. The analysis being that if you have a right to vote, you must have a right to be part of the democratic representative system, and therefore a right of political communication. And that has been one of the most important developments of the common law in Australia in terms of human rights. But here really is the rub. While freedom of speech is implied and protected by the common law principle of legality in Australia, Parliament can always override that freedom by enacting contrary laws that are clear and unambiguous. So that Parliament will pass, and has passed over the last few years, many laws that restrict freedom of speech, several of them prompted by concerns to criminalise the advocacy of terrorism, and which are perceived to have a denegatory impact on the Islamic community, particularly in Australia. But that little excursus into Australian, the extraordinary position of Australian human rights law, dependent on either parliamentary processes, which frequently fail, or on the courts, which have so limited a right to contradict clear languages of the Parliament statutes. With that in mind, I'd like to talk to you about the unprecedented debate that we've had in Australia in the context of the Racial Discrimination Act. The Act, I think you'll all be familiar with, but in Australia, in 1995, the then government introduced a new section of the Racial Discrimination Act, the now notorious sections 18C and D. 18C makes it unlawful to do an act in public that's reasonably likely in all the circumstances to offend, insult, humiliate or intimidate a person if the act was done because of race, colour or national or ethnic origin. So that is the Australian version of race hatred legislation. But it will be protected, the freedom of speech will be protected, if the offensive act that's offended, insulted, humiliated and intimidated was done in good faith, was fair comment, or was, for example, an artistic act that might include a cartoon. Now this provision, 18C, and the exclusionary protections for freedom of speech in 18D, were introduced at the express request of groups within the Australian community. The Australian Institute of Jewish Affairs and all the leaders of the Italian, Greek, Vietnamese and Chinese communities, following reports of the Law Reform Commission on Multiculturalism, the Royal Commission into Aboriginal Deaths in Custody, and the work of the Australian Human Rights Commission. So in introducing the law, it was done to reflect the deep concern within the Australian community that we needed some form of racial abuse prohibition, where it was on the grounds of race and a nationality and ethnic origin. And this law has been very, very rarely prosecuted. But interestingly, one might note that the protection of freedom of speech is one of the few legislative provisions in Australia that actually protects human rights, or that right. It comes as a negative, if you like, as an exclusion to a prosecution that might lie for offending and insulting someone on the grounds of race, etc. But it was very rarely used until calls for reform were prompted by a case known as the Bolt case, ETOC against Bolt, in 2011. And I'll tell you a little bit about that case because it's constantly referred to in the Australian media. What happened was that Andrew Bolt is a very well-known media commentator in Australia, and he was found by the Federal Court of Australia to have acted unlawfully in reporting that fair-skinned Aboriginal Australians abused their identity as Aborigines to claim welfare benefits and grants, art grants or grants for various societal purposes. And the 10 Aborigines concerned with this reporting were fair-skinned. They did get grants, some of them got welfare payments, and they were very upset at this report. They argued that 18C had been violated, that the articles were, in all the circumstances, likely to offend, insult, humiliate, and intimidate them on the grounds of race. Well, the court found that Bolt had indeed breached 18C because he'd acted in a way that was reasonably likely to offend, humiliate, and intimidate a person in public on the basis of race, etc. But the court then looked at whether 18C and the right to freedom of expression would exonerate Mr. Bolt from a successful prosecution. 18C, as I said, ensures that artistic works, scientific debate, fair comment are exempt. But the court found that Mr. Bolt could not claim the benefit of free speech because he wasn't acting reasonably, he wasn't acting in good faith, but was acting in bad faith. His report was neither fair nor journalistically accurate because he got his facts wrong about the racial background of the people he had abused, and because various other evidence was proven to be inaccurate. So in short, Mr. Bolt's right to freedom of speech was restricted because his journalism was considered by the judge to be an abuse of that right. Now, this case led to an absolute furore in Australia, in the media, who felt that it was an attack on media freedom and political commentary, and the issue was taken up by the newly elected coalition or Liberal government in Australia that was elected in September 2013. The coalition declared, in fact during the election campaign, that it would repeal 18C, despite the fact that it had been rarely prosecuted in practice. The public and political response then to the successful prosecution of Mr. Bolt became both unprecedented in Australian debate and highly divisive. The Prime Minister, the Attorney General, considered that the words offending and insulting placed the threshold for prosecution at too low a level. And they ridiculed the legislation, and they said Australians have no right to be protected against mere insults or offence. Australians were tougher than that. We were used to having a go at each other. We didn't have to be protected against this sort of journalism, and if a journalist wants to make these comments about First Nations peoples and insult them, well, that's all part of the cut and thrust of Australian life. And this argument had a bit of traction with the Australian public. They thought Bolt case had simply gone too far. Now, the judge was very, very careful to say in his judgment, there's absolutely no prohibition on questioning whether or not some Aboriginal Australians take advantage of their skins to claim welfare benefits. That is a criticism, it's a harsh one, it's not a very pleasant one, but it's one, it's a question that could be asked, and it could be answered by evidence, not anecdote, and not prejudice. So there was nothing wrong with raising the question. The question for the court was whether it was done in such a way that it breached the precise terms of Section 18C. And the conclusion being, of course, that as it was done in bad faith, on the basis of inaccurate journalism, then not only was an offence made out, but it was not protected by the free speech position. Well, at the Australian Human Rights Commission, we, of course, were expected to play a significant role in assisting with this either repeal or reform process. And we knew, I'd suggest, better than most, why the protection in 18C was so important. And that is that one of the statutory obligations of the Australian Human Rights Commission is to consider complaints from the public that there had been either a breach of international human rights law, particularly the International Covenant on Civil and Political Rights, or there's been a breach of domestic legislation, which in this case was the Racial Discrimination Act. And as President, I have to ultimately decide on each one of those 21,000 complaints. A third of them we dismiss as not having legal substance, but the rest we decide if there's a legal case to be made, and we embark on a process of investigation and conciliation with the complainant and with the entity that's been complained against. And about 70% of those cases are successfully conciliated. And I'd have to say, if I may, that that's part of the work of the Commission that I'm most proud of, because it doesn't cost the complainant anything at all to bring the complaint. All you need is an email or a telephone call, and it costs the respondent nothing to defend the matter, although some choose to bring a lawyer. But the key point is that because we handle 21,000 approximately every year, we've got a pretty clear view, and I'd suggest a clearer view even than the more senior courts, and we're not a court, but a clear view as to what it is ordinary Australians say is troubling to them in terms of basic human rights and anti-discrimination law. And we found that something like 10 to 15% of complaints concerned racial or religious abuse in public places. And one of the, particularly I might add, the workplace, in shopping centres and in public transports. And it is worrying that that element of racist and religious abuse exists in Australian public life, and we see it daily, and as I say, try to conciliate most matters, and we do. What has been particularly interesting has been the use of iPhones, because in the past we weren't always sure what the facts were. Did A abuse B in the bus, and witnesses that can be unreliable, or it might be just two of you. It will be a he said, she said kind of issue. But now we find that where there is abuse in the public arena, somebody will pull out the iPhone and video it. And we're immediately, when the complaint is made, it's probably already gone over the social media and seen by sometimes millions of people. But we now have a level of evidence that underpins the investigation and conciliation process that we've never had before. But what is worrying is that over the last couple of years, the incidence of racial abuse and religious abuse in the public arena has gone up in significant numbers. The year before last, it went up by something like 53%. And now it's settled down again. So it does vary depending on particular issues. But I go through or explain that to you simply to say that because of the work that we do at the Australian Human Rights Commission, we do know more than most just how insidious and frequent racial abuse is in a way that deeply damages the multicultural world that we live in Australia. We're all migrants, apart of course from our First Nations peoples, but we are all migrants. We all come from somewhere else with different religions, different languages, different backgrounds, and therefore it's seen as extremely important that we protect those rights. Now, before I tell you quite the end of that political story, I'd like to point out also that while the courts have only rarely had occasion to look at the race abuse laws, they have insisted that prosecutions apply only in the most egregious and deeply offensive and hurtful cases. So although the political argument was that offending and insulting was at too low a level, the courts have always insisted on a very high level. And let me just give you a few examples that have emerged in the courts. One was a stand-up comedian in the theatre who played an Aboriginal character called King Billy Coke Bottle as a grotesque caricature. And the court found that in the context of a comedy performance, the aim was clearly to give offence and to make jokes at the expense of someone in the community. But in the context of a theatrical performance, it was not out of proportion and not unreasonable and was therefore acceptable. Another, and happens in many, many societies, Jones and Tobin, Dr. Tobin was found guilty of willful contempt of court by publishing anti-Semitic material on the World Wide Web denying the Holocaust. This was challenged under Australian law, under Section 18C, and it's the first time in our jurisprudence that 18C had been applied to the internet and I think is likely to be the context in which we will see much racial abuse in the future, and indeed we are now. Just as I mentioned an advantage of using your iPhone to get the fact, or to determine what the evidence was, we are now seeing that the social media is being used as a vehicle for a greater level of racial and religious abuse than we've ever seen in the past. So these things are mixed blessings. Another very important decision by the then Chief Justice of Australia, Chief Justice Gleeson, who was looking at one of the race abuse cases, and he talked about one person's freedom ending where another's right begins, giving the example of a mother who takes her children to the park and supposes that they are exposed to threats, abuse and insults on the ground that they're immigrants to Australia. And he said, "Why should the family's right to the quiet enjoyment of a public space necessarily be regarded as subordinate to the abuser's right to free expression of what might be generously described as political opinion? The answer necessarily involves striking a balance between competing interests." And that is really what the Australian courts have attempted to do, almost invariably supporting artistic and journalistic works, even though they are found to be insulting, intimidating and humiliating. But one that raises the difficulty in practice of reaching an answer on that balance that Chief Justice Gleeson talked about is a case that perhaps you heard a little of in Hong Kong. It concerned a man called Monas, who was ultimately a man who used a gun to conduct a siege at the Lindt chocolate shop in Martin Place, leading to the deaths of 3 Australians. So you know the background to this case, but for many years, Monas was known to many organisations, including the Australian Human Rights Commission, the Attorney General's Department, to various legal bodies and to the police and to the courts, for his Islamic views, very strong views, and also because he deeply objected to Australia's involvement in the war in Afghanistan. And what he did was he wrote letters to the families of young Australian men who'd been killed in the fighting in Afghanistan. And those letters were seen as, to use the words of the court, denigrating and derogatory. And of course, the families were deeply upset by receiving these very offensive letters. And he was charged, and this is often the case in law, you never quite get the prosecution under what you think might be the appropriate law, but here he was prosecuted under Commonwealth Postal Services, using the Postal Service to send a letter that was regarded as menacing, harassing or offensive, but very similar in language to 18C itself. And the court said that the test is the restriction on freedom of speech necessary, proportionate to achieve a legitimate end. And the Chief Justice in particular agreed that if 18C or the postal provision was to be applicable, there would have to be a very strong reaction of anger, rage, distrust or hatred by the victims, the parents of the Australians killed. Well, the matter was appealed, there was a conviction, and the matter was appealed to the High Court of Australia. And the High Court looked at the law of race hatred and of giving offence. But of course, if it can happen, it will happen. We have 7 judges in the High Court of Australia, and one of them was yet to take up his appointment, and that left 6. And 6 split 3-3 on the legal question. 3 judges said the letters did not constitute a sufficiently high level of offence to be prohibited under the postal laws, and the other 3 judges, each of them women, I might add. You can draw your own conclusions from that, but it was the 3 women in the High Court who said, yes, these letters were deeply offensive, that the provisions were constitutionally valid, and that the criminal prosecution should rest. Now, I raise that question, that case, because it demonstrates that although one can come up with a legal standard of necessity and proportionality, even the finest juristic minds in the land are unable to conclude on the facts whether or not the criminal prosecution would continue. Now, as it did, in this case it did, and of course nobody was to know that it was Monas who, some 2 or 3 years later, would be a man who then sparked the attack in Martin Place, leading to the death of Australians. Well, what do these cases tell us? They tell us that that the courts have applied the provisions of insulting and offending, the race hatred laws, very conservatively, that if you're a journalist, if you're in the theatrical environment, or you're a cartoonist, you're very, very likely to be exonerated on the basis of freedom of speech. Now, with that legal background in mind, the Australian government nonetheless pursued the political aim of amending or repealing 18C. And I have to say that in an effort at compromise, I suggested that maybe we could use words other than offend and insult. If they put the threshold too low in the political mind, maybe we could use words like vilification or hatred that would perhaps make the point more clearly in the legislation. But that proposal was rejected. But it was most particularly rejected by the Australian community. And what was quite extraordinary to see, and I don't think we've ever seen this before, that migrant Australia came up in the worked together, Chinese with Indians, with British, with Malays, and with Aboriginal Australians, to say that 18C was absolutely vital to underpin the multicultural society in which we lived. And in short then, that race hatred laws applying also to religion are a vital component to a multicultural democratic society. That the right to freedom of speech was qualified, it was balanced, and in serious cases could be trumped, if you like, by the right not to be abused in public regions on the grounds of race or religion. Now, that public response was ultimately respected by the Australian government, and the Prime Minister announced that he would not continue with the attempts to withdraw the provision from the Race Discrimination Act. Now, I have gone into that level of detail to explain to you that it seems to me that core human rights and freedoms depend on community expectations, on communities' commitment to those principles. Now, there is obviously a role for leadership and political leadership, but I think the community must normatively accept human rights provisions if they're to be effectively maintained. So race hatred laws are now, I think, one of the vital foundations of Australia's pluralistic society, and I believe we should reform these laws with care on the basis of objective evidence, mindful of their symbolic values that underpin our democracy. Well, if I may then, I'd like to conclude by coming back to the question that I had posed to begin with. Would the cartoons published by Charlie Hebdo be protected if they were to be published in the Asian region, protected on the basis of freedom of speech? And I'd suggest that they probably would not survive regional laws that prohibit insults to religion and that protect racial harmony. And I think I'm open to debate on that question, but my impression of looking at the ways in which the laws operate throughout the Asian region, I suspect that where abuse that's deeply offensive on religious and racial grounds will be prosecuted. As for Australia, it's certainly possible that our courts could find the Charlie Hebdo cartoons deliberately offensive and not covered by fair comment, and thus in breach of the Race Discrimination Act. But I suggest it's more likely that 18D would protect artistic freedom to produce the cartoons so long as they're produced in good faith. Now, I'm not sure what good faith really means in this context. Can you be acting in good faith when you're acting in a way which is so profoundly disturbing and hurtful? And that really I must leave as a question, because I really don't know the answer to it. But I do know that racial and religious abuse, vilification and intimidation laws are critical for harmony in the Asian region. And I believe that so long as they are reasonable and proportionate, they can be an appropriate restriction on the right to freedom of speech. I believe it's vital that we work together to reach greater consensus within the Asian region, possibly through the ASEAN Declaration or something similar, with respect to our understanding of human rights. And as we celebrate the 30th anniversary of the Faculty of Education here at this great University of Hong Kong, it's appropriate to acknowledge the importance of education in ensuring a cultural commitment to racial and religious harmony and respect for freedom of speech. I wish the faculty very continued success in that broader educational objective. Thank you very much.